Today we have a special guest with us, Amanda
Yay.
Pierson with the Heights Law Group. And today we're going to be talking about,
Probate. Hi, Amanda.
Hi, how are you?
We're good. Thanks for joining us.
Absolutely. I'm excited to be here.
We're so happy. So, we're going to talk about probate. We're going to dumb it down for all y'all because not everybody knows what probate is, right?
Honestly, most people don't know what probate is. That's what I find every day in what I do.
And so, you're an estate planning and probate attorney. And probably
That-
people don't know what that is either, right?
That's absolutely right. So, estate planning and probate, they're two sides of the same coin. Estate planning is really wills and trusts, getting your affairs in order, getting your last wishes documented. Probate is what happens after you die. That's the legal process to bring your will to the court, show that it is your valid last will and testament, and then oversee the process of paying off debts and distributing assets.
So it's uber important that we all have this, especially whether you're married or even not, have children, going through a divorce, right?
yeah, it sounds like this is a really big, we're all going to die someday, right? It's not like we can just like, oh, I'm not going to have to worry about that problem. So it sounds like it's going to affect every one of us at some point in our lives or post life, right? So
Or our family members.
or who are, yeah. And it's especially, it's just, everyone's going to be affected by this.
Yeah, I don't think people love talking about it because it's hard, right? Like people don't want to talk about money, so it's hard. But this, I'm really glad you're here so we can like bring it to the surface and we can kind of delve in a little bit. And I know, the estate planning, like she said, is part of wills. So later we'll have a video on wills too. But let's start with just probate in general. You kind of gave us the definition of it, but what would you say are like three things that we as the public need to know about probate?
Absolutely. So the first thing is that if somebody dies in your family, the first thing people want to do is they want to access money to start paying off debts, right? That's the first thing they think of. They have funerals are expensive, burials are expensive, last medical expenses. They're expensive and you need the money. So people will go to the bank, they'll try to access their, mother, father, spouse's bank account and door shut. They need letters testamentary. So let's just talk the three big things to kind of know is what probate is. It's that process of proving up that will and being able to start making transactions on behalf of the state. How long does it take to get those letters testamentary, which is what you're going to need to start making transactions?
Mm-hmm.
It's you better leave at least 3 months, sometimes as long as 6. So
Three
that is
months.
another thing to be realistic about.
From the date of death?
From the date you get your attorney, really. So when you get your attorney is going to put together an application, is going to file with the court and get that process started. I have a probate right now. I filed last week, and right now it's December 5th. And the earliest probate hearing I can get, and this is in Harris County, is March 1st. So we
Wow.
took that hearing, of course, we wanted the hearing, but we're sitting until March 1st, and there is nothing that I can do to make it move faster. So timeline is important to keep in mind. And lastly, cost. You do
Let's go back for a second about timeline. I have a question because I heard you say something about the first availability with the courts being Harris County. Who actually shows up at the court? Is it
You?
Yeah.
It's me. It's always me. I show up at the court. It really depends on the type of probate. If I'm going to need witnesses, if I'm going to need the executor of the estate, I am always there. And a lot of times I will have the executor of the estate join me.
Mm-hmm.
Right now, Harris County in particular is entirely on Zoom for these initial hearings, which is fantastic. It makes it so much more cost efficient for everybody. Client can just pop on their computer. I can just pop on my computer.
Nice.
Right? You don't have to worry about your attorney sitting at the courthouse waiting to be called. So that's great right now is Harris County is all on Zoom. Fort Bend County is mostly on Zoom. And then it's just really county by county what they're doing right now for procedures.
So let's pretend like this was us and something happened and we hired you to handle the will. We have an executor, and so you file the papers, it goes into the county, you get the first available hearing, you're the one that shows up, and then you're presenting this will in front of the judge, getting approvals, correct?
Exactly. So I give the original will to the court. That's something important to keep in mind. I can't just take a copy. I need that original document. So the court is going to look at it before the hearing even starts. They actually kind of examine all of the wills that they have. They want to satisfy themselves that they're actually looking at an original document and not a copy. And once they're sure of that, that's when they'll actually let you schedule the hearing. They won't let you come in for a hearing until they know that they have your original will on file.
I'm curious about that. Like, what makes one document original? Is it stamped? Is it sealed? What's the? Is it like, blood on it? How do we make it original?
It is the original wet ink signatures that you will fill out in your attorney's office. So with
Like a blue pen?
Yes, with your pen, you'll sign it. That's why your attorneys will probably be old school. They'll have you sign in blue ink, right? Because it makes it just a little bit easier for the judge to tell that it's an original. Not that there's anything wrong with black ink or anything else, but helps the court know it's an original. And that is the one original for your will, because the moment you sign another will, your past will, your previous will is revoked. And copies of wills can be evidence of a will, but they're not the will. So you want to hold on to your original will and make sure that that original is delivered to the court.
So is it ever filed anywhere in case your house burns down or something and you don't have that original?
No. So I send my original documents home with clients. I encourage them to put it into a fireproof, waterproof safe in their house, not at a bank or anything like that, but in their house, and to kind of let the people, their immediate family, know where those documents are kept in case something happens to them.
All right. Well, so before we go into cost, what about those of us people out there that go, oh, I'll just go on LegalZoom and type something up? How sufficient is that?
With LegalZoom, you are not getting legal advice. So even as an attorney, having taken coursework in wills and estates, having done past the Texas bar, which has a section of wills and estates, I did at least 30 hours of additional training after I graduated from law school in specifically will drafting, not even probate, not even estate administration, just will drafting, to get to a point where I feel like I can counsel clients on what they need and what they should consider. If you go on LegalZoom, you're probably going to create a document that says best case scenario, who gets what. It is not going to think of all of the things that can happen, more or less. I think of all of the contingencies, things that have gone wrong on the probate side. I correct on the estate planning side. I can give you counsel and advice on, who to select for things, how to create trusts for your children, when those trusts should expire, who the trustees should be, when to amend. All of those things will kind of come with it. And the other part of it is I will oversee the signing to make sure it's actually done correctly. And a lot of times signings are not done correctly. So that's kind of the flip side of it.
So it sounds like to me that it's a fairly complex process that you're going to be walking them through. And it's not just, hey, sign here, here, you're good to go, right? Kind of thing. And that's where we always recommend that you get with people that are experts in their field, because there are situations that we've seen in the past where mistakes have happened or things aren't done correctly, that it causes way more trouble when they thought it was taken care of, right? So
absolutely, you do not want things to fall apart, because when your will comes into effect, you're gone. You can't fix things anymore. So you're really counting on this document. You work your entire life, right, to put aside savings and take care of, yourself and your family. I wouldn't, try to save a few $100s to avoid an attorney on this type of a thing.
That's good advice.
Yeah.
Well, I want to go back one more time too. Like, so what, I mean, I know now the definition of probate. So you go in front of a judge, and then has he ever said no to something? Like, where does that call come into play?
Yeah, absolutely. A judge can say no. Maybe they don't think it's the original will, right? They say this isn't an original will, this is a copy. You can have will contests, meaning somebody will come forward and say, hey, my father was not in his right mind when he executed this. 2000, he had dementia at that point. There's no way he executed this will and understood what he's doing. Or he was being pressured into it by, my stepmom was forcing him to execute his will and give her everything. So you can have will contests at that point where there's actually litigation that happens, and the judge will say, stop, I'm not going to admit this will. I'm not going to issue letters testamentary. and we'll kind of proceed with some caution and fully flush out what happened and decide.
Wow, that's
I mean, is there like a guideline, like we say most divorces are settled at 90% are settled in mediation. Is there a percentage that most of them are pretty, as long as it's an original will cut and like they go through like without a mess?
Yeah, I think that as long as you've got, an original will and it's properly executed and nobody's contesting that original will, you have those elements of it, then it will go through in the 3 to 6 months.
Okay.
So it really starts to fall apart if the will wasn't properly executed, it wasn't self-proved, if somebody's contesting the validity of the will. Those are the issues that kind of come to the surface and will just bring things to a dead halt.
All right.
sure. So I guess one more question, and then we'll go on to the kind of the cost of it. So in my mind, what we've been talking about in this whole situation is people that have had wills. What happens if you die and you don't have a will? You die, the term I'm going to say is instate?
Intestate, absolutely.
Intestate, I'm sorry.
Yeah, and that happens because realistically, the majority of people don't have wills in this country. So it happens all the time that people die without a will. And what happens then is you still have to go to court. You do something called an airship proceeding, but basically they're trying to figure out who the legal heirs are under Texas law. Okay, so that's the goal in an airship proceeding, and then it just goes from there. You don't really have any say or control in it. If you have an estranged child that you no longer speak with and you wouldn't have wanted them to inherit, they're probably going to inherit, right?
So that's where the power of the will comes into place, was when you actually want to decide what happens with your stuff after you're no longer here, right? It gives you the power now to make decisions what's going to happen in the future, right?
Absolutely. And, look at the situation. A lot of us have kids, right? We have kids that are minors, maybe. And with minor children, they can't inherit money outright. You can't give a baby a check for $1 million life insurance policy. It's not allowed.
Oh, come on. That'd be fun. I would want to see what a baby does with that, right?
Eat it.
A lot of pacifiers, right? So in those situations, you're going to have court proceedings to get a trust set up. And, there's a good chance that trust will not be administered how you would have wanted it to. It might terminate when the child turns 18. But with a will, you can kind of set up the terms for these trusts. You can say, I don't want the children to have access to it until they're 30. Maybe they get staggered distributions. There's so much that you can do with a will to really take care of people long into the future.
Well, so what's the timeline when you don't have a will and you pass away and your family has your house and rental houses and all that? What would be the timeline then?
It just depends on the complexity of your family. I mean, if you're a married couple, you have a surviving spouse and one child, it's not going to take very long. You have situations though where people don't probate. This is very common where people don't probate an estate because they didn't know that they had to. So you have an older generation, married couple, right? Wife dies, husband gets the house. Husband dies, he lets his kid live in the house, 40 years pass, and they try to sell that house finally. And suddenly you need to go through probate to move that house. Now, I had one recently when what's going on. Original married couple had 4 children. Of those 4 children, I think 3 of those children are dead now. So the heirship and the heirs that you're needing to track down are one of the original children, but now you're looking at all of these different grandchildren who are all inheriting different pieces of the estate. And there's a ton of people we need to get testimony from, and it's going to take a long time. And the problem there, which goes into our next topic, is that costs a lot of money, right? To need to interview and speak with all of these different witnesses and carve out all of these distributions in the estate. In a small estate, it starts to not be worth it.
So what you're telling me, but we haven't even talked about the actual cost yet, but you're telling me that the cost to not have a will is going to be probably more expensive than to have a will, right?
Yes, I would say an heirship proceeding will cost at least $1,000 more, just because there's a little bit more legwork that needs to go into determining who the heirs are for an estate, but it can be more than that depending on how long it's been since somebody died and the complexity of their estate.
And then you still don't know where exactly it's going, because you're you and someone else is maybe figuring out like, hey, this is actually the lineage of the family, and this is, we got to go up or down the chain and sideways or wherever. So it can be more complex and more hours, which you're an attorney, right? You're charging by the hour to do this kind of work, right? You're not just like going over there, it's going to be $7, right?
Yeah, right. Absolutely. So we have to charge by the hour, and that's unfortunate, but that's just how it goes. You usually get an item from the court as well to kind of oversee, make sure you're not acting in one heir's interest over another. That's going to cost. It is more expensive to have an heirship than to have a will probated. Absolutely.
So I think the biggest takeaway here that I'm hearing too is have a will first and foremost. But like, is there anything else a consumer who might have just clicked on this and was listening about probate that you would want them to know as an attorney?
Yeah, actually, I would say that probate can be avoided altogether with proper planning. So that is the last piece of it. Now, you can do a will-based estate plan. That's the most cost-effective. That's the easiest. You write the will, you're kind of done. But you can also set up what's called a revocable living trust. And with the trust-based plan, you actually transfer your assets into the trust during your life. And that way, when you die, there's no estate left. Your estate is entirely in your trust, and you don't have to go through probate at all.
Oh.
And that I've heard about those, and I say I'm novice to this, but that would be for someone maybe more senior that you would want to start up a living trust, or what age? I mean, would I do it at 30 or would I do it at 60? Kind of like.
It really just depends. I mean, a lot of my young couples who come in are doing catastrophic planning. They're doing the what if we get hit by a truck on our date night and our children, are left, right? Let's get something in place. It doesn't have to be perfect, but we need something now. So those clients who come to me with that kind of a goal, they're not going to be interested in a trust. It's not going to make sense for them. But as clients get older, a lot of my elderly clients, yes, but even some of my younger clients who just want to start moving their assets into a trust and operate through a trust, they're comfortable with that during their life, they'll just move forward with the trust-based plan, and it can work at any age. But certainly as you're starting to kind of wind down and tighten your estate, it's good to do it. Absolutely.
But this is where you can come into play and say, hey, based on your situation, based on what your number of assets are, you're going to advise your clients basically, hey, you should go will, it'll be easier for you, or you can go living trust route. And, you talk about the pros and cons of each of them, and then they can make an informed decision. Is what we always want to help our clients do, is make an informed decision about what they want to be doing with their assets, right?
Absolutely. Because even though a living trust is technically better on paper, it's not right for everybody. If you're not going to move your assets into your trust, if you don't have time, you've got a newborn, you're just busy at work, it's not in the cards for you, don't do it. It's just a waste of money. So
I love that. I love that you're being open and honest about that. Not to say, now this is the solution for everybody, they should do this. Because I've heard that before, that, hey, everyone just have a living trust, and they're just selling them on that thing, right? I like when we have people like yourself that just, are trying to look out for the best interest of the people and do a good job, right? And then inform them. And that's really what we want to do, is connect people, to like you, that just know their stuff and are experts in it.
Agreed. Yeah, I think too, like in any situation, whether it be you're getting a divorce, need an attorney, or you need someone to do a will, like again, you're just trying to find like-minded individuals. Don't always go with the first one. Maybe interview a couple, see what seems like a fit. Like I certainly don't want to like someone telling me, well, you have to do this. I'm like, why? I need to know why. So we appreciate the honesty. I'm sure everybody else does too. Because I think as consumers, we don't know. I mean, we're looking to the expert, right?
Right. And half my clients come to me saying they've never heard of a trust before, a living trust. The other half come to me and say, I was told I need to get a living trust. So, and in both situations, nobody actually knows what the trust is and the benefits and what it entails. So it's important to make an educated decision when you choose between those plans.
Yeah. I went to the library, and I think I might have told you this too. I had that probate and trust book, and it was like, it was like this thick. It was like thicker than the Bible. And I'm like, yeah. So
I've got a book for you. I go, I'm not reading that.
So
we know people.
Exactly. This is where
you got to know your talents, right?
Oh God, even if you would read it, it changes every year. So
well, that's a good point too. Yeah.
Yeah.
What year was that?
It was a 2020 edition. I don't know, but it doesn't matter. The point is that it's complicated, more complicated than to flipping through a few pages or going on LegalZoom.
Yeah,
and finding
always
that.
hire your team. You need a team, regardless of what the situation is. Hire the expert
Yeah,
that does it full time, not on the
exactly.
side.
Exactly.
That's my favorite thing. Oh, well, we do it half the time.
Well, they're a crossing guard, but they do some wills too.
I say that all the time. I'm a criminal defense attorney, but I can help you with your immigration.
Yeah, no. Do we go to heart surgeon that only does it half the time? No, we don't. So we really appreciate you being here.
Well, we're gonna cover the cost still.
She did say the cost.
Well, let's just do a highlight for that, and then we'll wrap it up.
Okay, let's begin.
Okay.
So, what is the cost of probate?
Absolutely. And that is going to depend on the complexity of the situation. If you have, a will, if you have an airship, what's going on there. But I would say to budget at least $2,500 for that probate. About between $600 and $700 of those will probably be court costs and fees, just hard costs. And then, the rest will be for your attorney and their paralegal, their time and preparing documents, attending the hearing, all of that. I've seen it go up to about 6,000, more or less.
Terrible.
Some complicated airships can get higher. And clients who want their attorney to just handle everything with the estate administration, as in going through the debts, going through the assets, really taking a hands-on role with the management there, you're going to pay for that as well. It's not legally required that your attorney do that, but some people are more comfortable with that.
Well, and it's a tough time for a lot of people too, right? So it's like, I don't want to be having to think about everything, because that's just everything's going to bring back memories, and I can't deal with it right now. I know when my dad passed away that it was really tough on my mom, and I had to step up and do a lot of things that I wasn't planning on doing. Luckily, they had some estate planning done. They knew like some of the part of was planned because he had cancer, and we kind of knew it was coming at some point. But I think like it was still hard on her to deal with some of those things. So we don't know what you're going to be able to deal with if, or whoever's left is what they're going to be able to take on, logistically.
Can you wait? Like someone passes away and you just are not in your right mind to even do anything? Like, is there a stipulation on timing?
You are supposed to probate a will within 4 years.
Oh, okay. So that's actually longer than I thought, to be honest. I thought it was like, okay, you got 60 days to do this.
No, you have 4 years. And the impetus for probating for a lot of people is I need the money.
Yeah, I figured.
Because you can't, like you said at the beginning. Yeah, you can't do anything until you've probated it, right? So otherwise the house is just sitting there costing you money. You're eating up maintenance.
Cousin Jeff sitting in the house.
Well, we don't want cousin Jeff sitting in the house either. So wrecking it, doing those, having his $6 to live in the room. So.
Well, I think that answers a ton of questions. Do you have any other specifics?
I mean, I think, no, we're going to have you back for another video, and we'll cover more of divorce and probate, and we'll cover wills. So we'll look for those 2 videos after this. But we'll link them up to above and below. But other than that,
thanks so much for joining us.
Thank you so much for having me. It's been fun.
Totally fun. We love having guests.
Okay.
So thanks so much for joining us. And as always, we're here to bring you real life experiences to all your real estate needs. Bye.
Okay. So
you are talking with your hands too much. I told you.